Okay. Go.
You hand me my screen box. Now go. Freak. Rah.
All right, so we are going on the record in the matter of the City of Wyandotte versus Jacob Moody, 192-956, as well as 212339. The State of Michigan versus Jacob Moody. And counsel, your appearance, please. I'm sorry? Oh, that's okay, as long as you're not passing out. That's
No,
fine.
I'm not. I had a big
I heard
breakfast.
your device going off.
I just took now. I had a big breakfast this morning, so
Very good, okay.
and that was good. Should have gotten to today. But Your Honor, John Goldclaw, P. 30758 on behalf of Mr. Moody, in file 212339, as well as in file 192956. One is a pretrial, which we have resolved, and the other, the 19 cases, is a sentence.
Okay, so.
I had an opportunity to speak with Mr. Moody regarding the sentence report. I want to note that I just received it this morning. This was originally scheduled for Mr. Westmoreland, but I've been filed.
Okay, Mr. Moody, your name for the record, please.
Jacob Moody.
All right, thank you. And the court will note that the sentencing in this matter was to have occurred back in 2000.
I believe Your Honor was
2022, but that's because there have been continued adjournment in 21 after defendant had failed to appear in 2019 and 20 also. So we've been waiting quite a while for Mr. Moody. And but you're here now, and so let's handle the driving while license suspended, the pretrial on that one, counsel.
Thank you, Your Honor. As I've indicated, I had an opportunity to discuss this matter with Mr. Moody as well as with the prosecuting attorney. It's my understanding that in return for a plea of guilty to operating driving on a suspended license first, the more serious charge of driving while licensed second would be dismissed. I've explained that to him. He understands that and wishes to avail himself of this opportunity.
All right, Mr. Moody, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. And you heard the plea that your attorney placed on the record, correct?
Yes, I did.
As to the amended charge of driving while license suspended first offense, how do you plead?
Guilty, Your Honor.
All right, counsel, please, order your client.
Thank you, Mr. Moody. On December 7th of 2021, were you operating a motor vehicle in the city of Wyandotte?
Yes, I was.
And did there come a point in time where you came in contact with Wyandotte Police Department?
Yes, I did.
And when they asked you to provide you with your driver's license, were you able to present that to them?
No, I was not.
And was that because it was suspended?
No. No,
Was
it was
your
revoked.
license suspended? Was revoked. Revoked. Okay, I apologize. So that was because the license was revoked, correct?
Yes, Your Honor. Or yes.
I don't want to demote your attorney, but okay. All right, the court has also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement, dismiss the original charge, and we can just do all one sentencing. But counsel, let me just go off the record for just one moment. I'll be right back, okay?
Thank you.
Just one moment.
Everyone, please rise.
As to sentencing on these matters. At first, as to sentencing on the 2019 matter for resisting and obstructing an officer.
Thank you, Madam. I've had an opportunity to review the pre-sentence report. I've spoken to Mr. Moody extensively regarding that. The court is well aware of his circumstances, particularly the situation where he has been incarcerated for there was a matter out of Flat Rock in 2022, and that was a felony controlled substance possession of cocaine or heroin, etc. He was incarcerated, I believe, on January 4th of 2024. Is that correct, sir?
2025. Or 2024.
2024. And with respect to that matter, and he has just been sentenced.
Wait, which matter?
He was incarcerated, not incarcerated. He was picked up And he's been in the Wayne County Jail since January 4th, on both the Flat Rock felony matter as well as on this particular case.
Oh, he ended up in custody on these two matters because there's warrants, but not because he turned himself in, but
No.
because he's in there on the Flat Rock matter.
Right.
So if you're asking for credit for time served on these matters, is that what you're going to ask for?
Well, I'm going to ask for some credit for time served on this matter, yes.
Okay.
And I'm just indicating that. I understand he was picked up, he didn't turn himself in, but he got picked up. Even, I believe he got picked up on not only the Flat Rock matter, but as well, warrants outstanding on all of it. I want to indicate that he was sentenced on the Flat Rock matter about a week ago, and he received at that point in time credit for 60 days served, as well as 2 years probation with all the standard conditions, drug testing, etc. He's also, I believe, as part of that, undergoing drug abuse, etc. We are not asking for credit for time served for all of that. However, Your Honor, he has explained to me the circumstances of what is going on in his life. He's turned his life around. He now has full custody of his 5-year-old son.
Is it a son or a daughter? I thought I remembered it being a daughter.
Son.
Okay.
And, Your Honor, also, once he is released from custody, he has his job waiting for him. He's a union employee, and he works with his stepdad. Is that correct, sir?
Yes.
He lives with his mother and, I'm sorry, you live with your mother?
My mother and my stepdad, they're helping me with my son.
And your stepdad. I'm sorry, I agree. And
His mother. Go ahead.
they've been taking care of his son. Your Honor, it's his stepdad who will be making sure, I believe, no, you tell me it was your father?
My stepfather will be driving me to and from work.
While he continues to clear up his further problems with respect to that. He cleared up all of his outstanding warrants recently, except for one. He has one driving while license suspended out of Saline, which he will be taking care of as soon as he is released or able to resolve with that. I know that he has an extensive record, Your Honor. We are asking with respect to the sentencing for the R&O, the recommendation, of course, is fines and costs. We are asking rather fines and costs and incarceration that be placed on the term of probation to run concurrent, concurrent, at the same time. That's a 2-year probation that is on out of the Third Circuit Court. Also, Your Honor, we are asking for some time served, and we would ask that since he's been incarcerated for over 80 days, that we at least get credit for 30 days on the sentencing for both matters.
Why should your client get credit for 30 days in custody on these matters when he has been in custody up until 2 weeks ago for the Flat Rock matter only? Quite frankly, because he was waiting for that matter to conclude.
Well, it's my understanding, Your Honor, that though he was in custody regarding with Flat Rock, he was also arrested or detained.
What was his bond for the Flat Rock matter? What was the Flat Rock matter again?
It was a controlled substance.
Okay.
No.
And
as he indicated to me, Your Honor, he clearly understands he has a terrible all of it.
well, but hold on. But my question is still this: what was the bond on the Flat Rock matter?
I did not have a bond, Your Honor.
There's a no bond.
I was sentenced to 60 days, and then I've been here. I served my 60. Go ahead.
Okay, listen, please. When you were arraigned, you were either given a bond or you weren't, or so.
No, I was not.
You were given no bond.
Or I had a handful of warrants, so I had a $250,000 cash or 10% bond. I've had a total of 11 warrants, I believe, and I've taken care of all of them up until this one and the Celine.
Right.
I said last
Well,
time I was here.
You've taken care of them because you've been in the Wayne County Jail, so they were zooming you in at the respective courts.
Yes.
So, well, yes, you've cleared some of your warrants. My point is, counsel, is that your client didn't even have a bond. So it isn't as though he was in custody for our matters specifically. So I'm not giving your client any credit for the time served. But what I'm going to do is, I'm not placing your client on probation. So he's down to 3 warrants. He owes the court $150 still from another driving license suspended matter from 2021. That's case number 211771, so it's not the same one. So what I'm going to do is on your driving license suspended matter 212339, I'm going to waive your fines and costs.
Thank you, Ron.
On that one. That one's done. Then the court's going to, on your 192956 matter, the court's going to order 45 days jail, waiving the fines and costs. So 45 more days in jail, sir.
Or consider at least giving him credit for 1 week since from the date that he was sentenced on the Flat Rock matter until today.
We still have other matters. How do we know he was
Your
lying?
Honor, Your Honor, may I say
Yes.
something? I understand that I've had complete disrespect to the courts, and the reason is because of my drug use. I've been obviously I've been in here for 80 days. I've been 80 days clean, and I'm going to continue on this path. I'm trying. I need to see it. I need to go to a doctor. I have an abscessed tooth right now, and I've been here for 80 days, and I haven't been able to get any help from that. I would ask if I could be put on probation because I believe it could help me as well as the other probation. I have my other probation stuff here, but I'm
Okay,
looking
so let
to
me,
just change my life around.
okay. And I hear everything you're saying. And I'm glad to see that you're at 90 days clean since you've been in custody. I
want to get back to my son.
I understand that, sir. I understand that. But I also have a responsibility as well in this matter. And you have failed to appear a number of times. I don't find that you're a candidate for probation, given your criminal history and your failure to appear on a number of occasions here in this court over the last 5 years.
Your Honor?
4 and a half years. And so, sir,
could I ask for one sober chance?
Sir, you're going to get your sober chance after you serve your 45 days jail.
Probation.
You're going to get your sober chance to not reoffend and not end up back in this court. I've waived all of your fines and costs up for you, sir. So you don't have that. Although you still have a matter from 2021 that you owe $150 on. I'll give your client 7 days credit, counsel, since his matter was already resolved. That's it. You're getting 7 days credit. That's all you get.
I'm asking for a sober chance, and I won't let you down. This will be the first time I've been able.
Mr. Moody, I am glad that you are sober. The fact that you are sober is not the sole determining factor as to what this court's doing.
I'm not saying.
I have to take a totality of circumstances into account, which I have done and I've stated on the record. So that is the order of the court. Good luck to you, sir.
Thank you.
Thank you. State of Michigan versus Simon Herrera, 2412.
Good afternoon, Judge. Jeff Perlman on behalf of Mr. Herrera, who's approaching. So state your name for the record. Simon Herrera.
All right, good afternoon. Okay. And so today is the date scheduled for sentencing in this matter on Mr. Herrera's plea to an amended charge of domestic violence reduced from child abuse 4th degree. And council, do you have an opportunity to review the report and recommendation with your client?
Yes, I have, Judge. There are no corrections or deletions or additions that you can enter.
Okay. And council, as to the recommendation.
That's the recommendation, Judge. The only thing I would say is that because my client works full time and overtime is very busy and involved with work, this seems quite a extensive number of requirements and perhaps redundant in certain respects.
Council, I'm sorry, are you on your phone?
I'm looking at the recommendation, sorry.
Okay.
And I would just indicate that he is. I would just ask that there's a domestic violence counseling course and a parenting class recommendation. I've just asked the court choose one of those options as opposed to both. And otherwise, my client has we have no issue with the recommendation.
Okay. Well, quite frankly, the allegations in this case are actually pretty disturbing. I read the report. I read the statements from your daughter. I read your statement, sir, and that was your response to your daughter hitting you, is what you've indicated. There's, quite frankly, if your daughter hit you, right, that isn't appropriate, that's not appropriate. But to strike your child with a closed fist in the head multiple times is unacceptable. At that point, when your child struck you, which, again, if that's what happened, that shouldn't have happened. As the adult and the parent, as frustrated as you were, as frustrated as you would have been, you should have gotten up and walked away. I am willing to bet that there are some deep-rooted issues as to why your daughter was frustrated with you that caused her to slap you. Which, again, she should not have done. But she is your child, 14, and your response to that. So in addition to domestic violence counseling, you absolutely need parenting classes. I don't know what's going on with the petition for guardianship regarding your daughter. I don't know what's going on with the CPS matter, if that's still pending. I don't know. But this went above and beyond discipline. Above and beyond discipline. And after reviewing the report, the recommendation, the accompanying documents, hearing from counsel, the court finds that there is reasonable grounds to Department of MCL 769.5. The court finds the recommendation is appropriate. The court's going to order 24 months probation. You're not eligible for early discharge. You are eligible under 769.4A. And the court's going to order the following conditions. You're not to violate any criminal law of any government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You notify your probation officer immediately of any change in address or employment status. You not use any alcohol or drugs unless prescribed and be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You have to participate in outpatient substance use counseling. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so that you may maintain sobriety and prevent relapse, hopefully preventing anything like this from happening again in the future. You are not to have any contact with your daughter, Abigail Herrera. That's phone contact, text message, email, social media, third party, anything of the like. If there's an order from the circuit court, whether it's from the CPS proceedings or the guardianship proceedings, and they're ordering parenting time to occur, then there needs to be a motion to amend the probation condition filed with this court so that we can determine what we're doing with that. Okay.
Judge, there are no restrictions. The CPS code case, I don't think anything has come of that, and there are no restrictions in terms of any guardianship or any other type of case. The court were willing to consider no assaultive contact. Again, my client does not live with his daughter, and but I do think it's important that ultimately that they work out their differences in a healthy way.
I would agree. However, there is a request to continue the no contact order. So at this point, the court's going to continue the no contact order. What I'm stating is if there is an order from the circuit court that orders there to be family counseling, reunification plan, something of that nature that would require contact with Abigail, then there needs to be a motion filed here with the court so the court can review all of that. Because the circuit court can't just say, disregard the district court order and start talking to your daughter. That's not how that works. There has to be a motion filed here with this court first. You're also to not return to the residence where Abigail lives, nor to her school. You're also not to possess or have any or purchase any weapons or firearms. The rehabilitative goal for that condition is to ensure victim safety and community safety. You're to participate in 26-week domestic violence counseling. The rehabilitative goal for that condition is to increase your understanding of your responsibility for your actions, to educate you about how to modify your behavior, manage potentially abusive situations in a safe fashion. And the court's going to also order you to participate in parenting classes. The rehabilitative goal for that condition is to teach you how to deal with daily responsibilities of maintaining a positive home environment and ensuring children's health and safety, as well as preparing your children for life as productive adults. Do you have any questions regarding the terms and conditions?
No, ma'am.
All right. The court's going to order a $500 fine, $100 screening assessment fee, $1,200 supervision oversight fee. That's $50 a month at 12 months. At 24 months. $400 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, a total of $2,325. All right, please have a seat in probation and somebody will be with you shortly. All right, we're on the record in the matter of the state of Michigan versus Andrew Jewett, 24254. Good morning.
General for P 30758 on behalf of Mr. Jewett.
All right, and Mr. Jewett, your name, please.
Andrew Jewett.
Okay, and today's the date scheduled for the arraignment pretrial in this matter. And Mr. Ashadra, your appearance, please.
Your Honor,
Good afternoon.
He was arraigned out down there.
I'm sorry, he was. This is the pretrial.
Good morning, Your Honor. Omar Shahjar on behalf of the people, PA 6232.
All right, thank you. All right, and counsel?
Your Honor, at this time, I've discussed this matter with Mr. Jewett. We reviewed the matter, and at this time, we're asking for a new final pretrial to obtain discovery in this matter. The discovery order has been.
Yes.
Has been presented.
Yes, the court has signed the discovery order. Would April 4th work, counsel?
I believe I'm on the calendar.
You're on the calendar that date.
That'll work.
I did have an opportunity to speak with the complaining witness on this case, Ms. Martin. She is on the Zoom. She indicated to me that she wishes to have no assaultive contact with the defendant. It's my understanding, based on my conversation with her, that she is pregnant with the defendant's baby and they would like to speak as it pertains to doctor's appointments and such. Ms. Martin, could you please state your name for the record?
Yes, my name is Hunter Martin.
And so, ma'am, you are asking this court to amend the no contact to be no assaultive, harassing, threatening, intimidating contact?
Right. I was also asking for the anger management and the therapy for him.
Okay, I can't necessarily order that as a condition of bond. I can let you know as it relates to this matter that we do have a mental health treatment court if your client is interested in that, counsel, to participate in that. I see you shaking your head.
Well, I understand at this point, Your Honor, I understand that. We will address that issue as the time comes.
Right. So I can't necessarily order that as conditions of bond right now, ma'am, because, is your client currently
Nothing, Your Honor.
participating in any mental health treatment at
Your
all?
Honor, he has no prior criminal record. He has no history of mental health.
Okay,
at this point in time.
I'm just curious, if he was, I was just gonna order him to, appear, continue with that, but, he isn't, so at this point, ma'am, I can't order that. Not that I can't order that, but I don't have any basis to order that at this particular moment. I'm not saying that if Mr. Jewett is placed on probation, I'm not saying that would not be a condition of probation, just at this point, the court is not able to order that. And so, Ms. Martin, you want to communicate for the limited purpose of doctor appointments and the baby that you're pregnant with?
Yeah, so as far as if Andrew would want to communicate about the child, I don't know if he wants to be involved with the pregnancy. If he wants to communicate, then I would like for it to be non-assaultive communication.
All right, so I'll leave it. Are you interested in communicating about the baby, sir?
No, ma'am.
No, you're not interested in communicating about the baby?
No.
Okay, so he says he's not interested in communicating about the baby. Do you want to keep the no contact as is, or do you still want it to be amended?
I mean, we can amend it. I'm sure he'll change his mind. Everybody wants to talk to the mother of their child. So, of course, him being abusive and domestically violent to me and the way that he was to me, it does make me fearful for him contacting me, especially him using the words, I'm going to kill you, I'm going to kill your dog. Those are the things that I don't want him to say. So those are the words that I don't want it to be assaultive contact. I don't want him to say things like that to me, threats.
Okay. So, Mr. Gopa,
Your Honor, I understand her position. So does Mr. Jewett. To be quite honest with you, he has denied ever making those statements, which he has raised on this record. And it appears that she wishes to have this contact. My client has no objection, but he is not going to initiate it. That be a fair statement. If she should call him, then he would not be in violation of any. As we know, no contact means no contact. And even if somebody, this court, in any court, then answers the phone from the complaining victim and responds to that, if there's no contact whatsoever, he or she, is that the matter could be ended up violating terms and conditions of bond. Now, if the phone contact is initiated by Ms. Martin, then he would be able to at least discuss that matter with her as she's requested. But at this time, Mr. Jewett is indicating that he will not be initiating any contact.
okay. Mr. Shadra, you want to weigh in on this anywhere or at any point or no? Are you all?
No, Judge, I think we've addressed everything. I mean, in the event that the defendant is willing to take a plea, as I indicated to Ms. Martin, we could condition the plea on anger management and any mental health treatment that she would like. So I think we've addressed everything. Thank you, Judge.
Okay. All right. And so, Ms. Martin, you still are requesting this court to amend the no contact to be no assaultive, threatening, harassing, intimidating contact, correct?
Yes, I am, which means that he would be able to contact me without getting in trouble as long as it's not assaultive. I just want him to understand that.
Yes, I believe his attorney has indicated that to him as well. So the court will then adopt the record, amend the bond condition of no contact to be no assaultive, harassing, threatening, intimidating contact with the defendant, or with the victim, I'm sorry. The bond and balance of conditions are continued.
Thank you, Your Honor.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. He's going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
no case for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.